community in an 8-county area in central Wisconsin. So before we begin, I just want to make a disclaimer. I gathered the information that I'm going to present this morning from what I believe to be reliable resources. That is becoming more and more of a challenge these days. My information comes principally from the Department of Homeland Security. You can access its website at dhs.gov. It changes frequently in this area. Another resource that I've relied on is the National Immigration Law Center. You can access their website at nilc.org. And then finally, an organization called CLINIC, which stands for Catholic Legal Immigration Network Incorporated. You can access their website at cliniclegal, all one word, .org. So my presentation this morning is provided for general informational purposes. It is not to be considered legal advice to anyone other than OLA. It's not intended to create an attorney-client relationship between anyone listening to the presentation and me or my law firm. And unless you're a member of the board of directors of OLA, you shouldn't rely on anything I'm saying. You should seek the advice of your own attorney. Finally, this is a rapidly changing area. And I have tried to obtain information that is current as of 5 p.m. yesterday. I have no idea what might have happened overnight, and I have no idea if the government's interpretation of whatever it has previously announced has changed or whether it's going to change. So I want to start out this morning by talking about an agency of the United States government that is commonly referred to as ICE, ICE, and what its agents may lawfully do carrying out their law enforcement activities and what they may not do. In 2003, Congress approved a major effort to boost our national security in the wake of the September 11th terror attacks. It created a new department with cabinet rankings called the Department of Homeland Security. And within the Department of Homeland Security, Congress created a law enforcement agency called Immigration and Customs Enforcement. And that's where the ICE comes from. It's Immigration and Customs Enforcement. And the purpose of that agency was to handle immigration enforcement, investigate criminal activities related to immigration, and enforce our customs laws. ICE has over 20,000 people, according to its website, in more than 400 offices located throughout the United States and around the world. And according to its website, it has an annual budget of about $9 billion. I think everyone listening to this presentation goes through a two-step process in thinking about your work and the work of your organization when it comes to the immigration space. First of all, you want to know what the rules are. I mean, ICE agents want to know what the rules are, and everybody working in dealing with people who are affected by our immigration policies in this country want to know what the rules are. Second, everybody might have an opinion about what those rules say and how they affect you, how they affect your agency, how they affect the people you serve, or even how they affect the nation as a whole. But first, you want to know what the rules are, some rule clarity. And by the way, when I mentioned the immigration space, obviously, I'm talking about people who are immigrants in our country, but also government officials, law enforcement officials, people who work for advocacy organizations. It's everybody who is working in that area. OLA, as its name implies, focuses on the needs of the Latino community in the central Wisconsin area. But like the rest of the country, central Wisconsin has been a host of immigrants from many parts of the world ever since the missionaries and the explorers came to this part of the country from Europe. With respect to rule clarity, this is confusing for me. I think it's confusing for most people in the country, including people who have the responsibility of carrying out law enforcement functions. So here are the key players as of today. There is an acting director of ICE. So his name is Caleb Vitello. You don't hear very much about him. He actually has experience in immigration and immigration enforcement. So he reports to the Secretary of the Department of Homeland Security. So there's a brand new secretary. Her name is Kristi Noem. She was nominated by President Trump to be the department secretary. She was confirmed a few days ago by the United States Senate. She's been serving as governor of the state of South Dakota. Uh, According to her official bio, she doesn't appear to have any experience directly in the immigration area, but she is the department secretary. Then there are some White House officials who are also playing a key role in immigration policy, immigration messaging, and frequently speaking out. So outside of the Department of Homeland Security and within the White House, this includes Caroline Leavitt, who's the who is the White House spokeswoman, and then Stephen Miller, a name that many of you have heard. So he is Deputy Chief of Staff at the White House. And then a man named Tom Homan. So he used to be the acting director of ICE, but now when he is speaking about immigration matters, he's speaking on behalf of the White House in his new position, which had never existed before, which is called, well, President Trump calls it the border czar. So he doesn't represent the Department of Homeland Security. And it remains to be seen how much of a voice he's going to have on policy. It remains to be seen how Kristi Noem, the Secretary of the Department of Homeland Security, and Tom Homan, the border czar, work out their roles. My guess is that there's going to be quite a few internal discussions on who actually speaks for policy of the United States government. And then, of course, there's President Trump. Because he's president, like any other president, he reserves the right to comment on immigration issues, speaking about it, and posting messages on his social media platform. So regardless of what the Department of Homeland Security says, and regardless of what even the border czar says, the president can say whatever he wants to say because he's the president. So how are ICE priorities and its policies changing or have changed just in the last couple of weeks since Donald Trump became president? Well, first of all, just like under the Obama administration, the Biden administration, the first Trump administration, ICE officials are continuing to carry out their normal day-to-day operations. According to my Google search, the Obama administration deported about 3.16 million people during his first two terms, earning him the nickname of Deporter in Chief. The first Trump administration deported around 3.1 million people, and the Biden administration so far has the record of deporting approximately 4.4 million people. And each administration has had its own approach and its own policies. All three of those administrations have emphasized their priority in going after what they call criminals. But a key difference with some officials over the last 2 weeks in the second Trump administration is how you define the term criminal. President Trump often includes, if you do a Google search, when he refers to criminals in the immigration context, often the words near that is murderers, drug dealers, and or rapists. Mr. Holman, the border czar, in interviews that he has conducted, has used the same terminology. But after a highly publicized ICE raid in New York a few days ago, ICE officials, not White House officials, but ICE officials announced that some of the people that they apprehended had serious criminal records. But they also mentioned that some of the people that they apprehended had no prior criminal records. And then there's a White House spokeswoman, Carolyn Leavitt, who said this week that the administration sees all undocumented immigrants as, quote, criminals. Those were her words. And this is what she said at her recent press briefing a couple days ago. Of course, she said, the criminal drug dealers, the rapists, the murderers, the individuals who have committed heinous acts on the interior of our country and who have terrorized law-abiding American citizens, absolutely, those should be the priority of ICE. But then she said, but that doesn't mean that the other illegal criminals who entered our nation's borders are off the table. Well, in my world, and I think in the agencies that you represent, the jobs that you carry out, words matter. And technically, Carolyn Leavitt is correct in referring to people who have violated the law as criminals. But it's a matter of degree, because in talking about people who have entered or crossed the border, if you do that without authorization, you are guilty of a misdemeanor. And on the other hand, if you're caught re-entering the country after you have been deported or removed, that becomes a felony with much harsher consequences. So that raises a question in my mind, just a personal comment, and that is, do we mislead people when we use this politically charged rhetoric? Is it helpful in advancing a discussion about creating and implementing effective immigration policies, which I think everyone in the country wants for the good of the country? Personally, I don't think so, and here's why. Misdemeanors usually result in fines and usually result in somebody having to spend some time in a local jail or a county jail. And here are some examples, just to give you an idea of what comes in this category of a misdemeanor. Well, petty theft is a misdemeanor. Disorderly conduct is a misdemeanor. Assault without causing significant injury is a misdemeanor. Trespassing is a misdemeanor. And crossing the border without authorization on a first offense is a misdemeanor. So is it helpful to call these people criminals? I mean, does it advance the discussion? My grandfather lied about his age to immigration officials at Ellis Island. He committed a misdemeanor. After he raised 8 children, started 3 bakeries, owned a couple of apartment buildings, was the pillar of the church in his community. I just never saw him as a criminal. But he did commit a misdemeanor. He didn't tell the truth. Now, felonies are much more serious. That's the murder, rape, armed robbery, fraud, and for our purposes today, crossing the border after you have been removed or have been deported previously. And that results in imprisonment of usually 2 years or more, or up to 2 years or more. What about overstaying a visa? There are a lot of undocumented people in the United States who entered the country with a valid visa, but then remained in the country after their visa expired. So Elon Musk's brother testified under oath in a trial deposition that he and his brother Elon overstayed their student visas. Now, obviously, Elon Musk was not detained and deported. But even if he had been detained and deported, he wouldn't be considered a criminal. That's because people who overstay the expiration date of their visa are subject to civil penalties. They're not subject to criminal penalties. It can have serious consequences. You can be deported, and depending on how long you overstayed your visa, you might not be able to re-enter the United States for 3 years. You might not be able to re-enter the United States for 10 years. It just depends on the time you overstayed. But you are not a criminal. You are simply a person who is not authorized to be in the United States. So my point in all of this is to urge people who are working in the immigration space in any capacity to refrain from using what I consider to be politically charged terminology, which can be misleading, and terminology that demeans human beings. One of the things that we try to do at OLA is to use accurate and respectful terminology. That keeps the focus on issues and not personalities. So we try to use more precise terminology. This is the terminology that prosecutors, defense attorneys, judges, even administrative law judges in the Department of Homeland Security use. We refer to ICE agents as ICE agents without calling them names. We refer to police officers as what they are. They're police officers. And we try to refer to people without questioning their legal status, people who are not authorized to be in the United States for whatever reason, as undocumented people. It focuses on whether they have the right documentation or not, and it doesn't get into what their legal status is. The second change, excuse me, so I want to talk about now some changes that have occurred in ICE policies that have attracted a lot of attention in the last 2 weeks. The first change isn't mentioned very often, but I think it's pretty significant. So administratively, ICE operates in 2 divisions. The one we hear about most frequently is enforcement and removal operations. So they do exactly what the name suggests they do. One of President Trump's executive orders on January 20th marks a significant priority shift in the other division of ICE, which is called Homeland Security Investigations. That has, ever since it started, had a focus of investigating child pornography, human trafficking, and something called antiquities fraud. But the major shift now, as of January 20th, is that President Trump's executive order has changed the primary mission of that division to be enforcing immigration laws and, quote, other federal laws related to the illegal entry and unlawful presence of aliens. So that is a major policy shift. It doesn't get too much attention from the media, however. The second change does get a lot of attention, or has gotten a lot of attention, and that is an executive order allowing ICE agents to conduct enforcement actions in what are called protected areas. Sometimes you hear them referred to as sensitive areas or sensitive locations, places that since 2011, 3 administrations ago, required more steps before ICE officials could initiate arrests. So in 2011, the person who was then the Secretary of the Department of Homeland Security issued a memorandum to provide guidance for ICE enforcement actions in and near, not just in, but near these protected areas. That guidance was revised by the person who was the Homeland Secretary in 2013, and then it was further revised by Alejandro Mayorkas in 2021. So I want to read parts of that 2021 memorandum from Secretary Mayorkas because I think it gives us a feel of the policy goals that he was advancing. And this, by the way, is what has all been changed. So in his memorandum, he talked about a foundational principle. He says, when we conduct an enforcement action, whether it's an arrest, a search, service of a subpoena, or other action, we need to consider many factors, including the location in which we're conducting the action and its impact on other people and broader societal interests. To the fullest extent possible, we should not take an enforcement action in or near a location that would restrain people's access to essential services or engagement in essential activities. That is the type of location that he calls the protected area. He says this principle is fundamental. We can accomplish our enforcement mission without denying or limiting individuals' access to needed medical care, children access to their schools, the displaced access to food and shelter, people of faith access to their places of worship, and more. Adherence to this principle is one bedrock of our stature as public servants. So he then gave some specific examples, not all inclusive, but as a guidance. He wanted ICE officials and also people like everyone in this room to understand what the government means by protected areas. So he starts a school. That includes a preschool, a primary, secondary school, vocational school, trade school, college, university, a medical or mental health care facility, a hospital's doctor office, health clinic, vaccination and testing site, an urgent care center, a site that serves pregnant individuals, or a community health center, a place of worship or religious study, whether in a structure dedicated to activities of faith, such as a church or a religious school, or even a temporary facility or a location where those types of activities are taking place. A place where children gather. That could be a playground. It could be a recreation center, a child care center, before and after school care center, a foster care facility, a group home for children, or a school bus stop. A social services establishment. That could be a crisis center, a domestic violence shelter, victim service center, child advocacy center, supervised visitation center, family justice center, a community-based organization, a facility that serves disabled persons, a homeless shelter, drug or alcohol counseling, and a treatment facility, or a food bank, or a pantry, or other establishment distributing food or other essentials of life to people in need. It might be a place where disaster or emergency response is provided, such as evacuation routes, shelter, emergency supplies, food and water are being distributed. It includes a place where a funeral, a graveside, a ceremony, rosary, wedding, or other religious or civil ceremonies or observances occur. And it even includes a place where there's an ongoing parade, a demonstration, or a rally. Generally speaking, it's places where reasonable people would have a reasonable expectation of being protected from law enforcement activities. Unless, of course, there's a crime being committed. So he says a fundamental question is whether our enforcement action would restrain people from accessing the protected area to receive essential services or engage in essential activities. And then he outlined some exceptions where judgment can be used by law enforcement officials. Pretty reasonable stuff. If there's an imminent risk of death, if there's violence, if there's physical harm to a person, if the enforcement action involves the hot pursuit of an individual who poses a public safety threat. Those are exceptions to the rule. So that's what we've had in place to give guidance for the whole country, but especially for people who are trying to carry out their responsibilities for immigration law enforcement. So this is a 5-page single-spaced guidance that in one form or another has existed since 2011. So here's the new guidance that was issued on January 20th. And it comes from the person who was acting Secretary of Department of Homeland Security at the time. So it says that this memorandum addresses enforcement actions in or near areas that the Department of Homeland Security previously determined require special protection. As part of the work of our brave men and women in uniform, officers frequently apply enforcement discretion to balance a variety of interests, including the degree to which any law enforcement action occurs in a sensitive location. Going forward, law enforcement officers should continue to use that discretion along with a healthy dose of common sense. Common sense is typically not a legal standard. Common sense is typically not guidance that you would rely on, I don't think, in your organizations for your staff to try to understand the expectations, try to understand their roles in your organization. But that's the guiding principle that we have now as of January 20th, because the detailed guidance has been revoked. This directive ends by saying it is not necessary for the head of the agency to create bright line rules regarding where our immigration laws are permitted to be enforced. The director of ICE may wish to issue further guidance to assist officers in exercising appropriate enforcement discretion. if I had to bet, I would bet that the Department of Homeland Security, its new secretary, her staff is going to issue something more concrete to guide their ICE agents and their entire staff than than the new standard of using discretion, balancing a variety of interests, and a healthy dose of common sense. So, what does that new policy directive, what does that mean for your organization? What does that mean for the people who have the responsibility of enforcing our laws? I'm going to refer you to one of the resources that I mentioned before, the National Immigration Law Center. And again, you can access this material at nilc.org. And the reason I mention it is because people in this room, people on the video link represent all sorts of different organizations. And at the National Immigration Law Center website, there are specific recommendations as of January 25, when they put their materials together, specific recommendations for school administrators and staff, specific recommendations for hospitals and health centers. You can just click on, find whatever area you're involved in, and there are recommendations for what you might consider to be best practices given the change in policy. There's a separate spot for recommendations for social service organizations, and there is a separate spot for recommendations for places of worship.
Yeah.
The concern about a what I would call a unspecific and rather loose standard of exercising discretion and being guided by a healthy dose of common sense is that it can have a chilling effect on the immigrant communities who might be afraid to access medical care. They might be afraid to send their kids to school. They might be afraid of going to child care or places of worship. That is a problem for everybody who's trying to deliver important services to people in those areas. So you might ask, so what legal protections remain for your agency, your organization, and the people that you serve? Well, any policy that is announced by a cabinet official or any policy that is announced by somebody who is a spokesperson for the White House, regardless of who is president, doesn't change the United States Constitution. So what is in place is the Constitution and the Fourth Amendment, which protects all individuals, regardless of their immigration status. The United States Constitution doesn't refer to protections for citizens. It refers to persons who are located within the United States, regardless of their status. So the Fourth Amendment protects all individuals from unreasonable searches and seizures. That is still in place. What is reasonable? What is unreasonable? That is something that federal courts have decided. There is fairly clear current guidance on what is considered on U.S. Supreme Court rulings to be reasonable under the circumstances and what has been found to be unreasonable under the circumstances. All of that is still in place. And then almost as importantly, or maybe even more importantly, for people that you serve, And your staff is the Fifth Amendment protection that ensures the right to remain silent when confronted by law enforcement. Everybody located in the United States, regardless of their status, still has the constitutional right to not incriminate themselves. They don't have to answer questions. What they should do, if they don't want to answer questions, is simply say, I choose to exercise my right to remain silent until I've had an opportunity to speak to my attorney. On the OLA website, which is HOLAWISC, HOLAWISC.org, you'll find on the OLA website a brochure in English and in Spanish called Know Your Rights. And in that brochure is what we call a Know Your Rights card. It's something that you can just cut out, and if you or anybody else you know has any concern about their immigration status and does not want to answer questions until they've had the opportunity to consult with their attorney, they can simply hand that Know Your Rights card. And it simply says that they're choosing to exercise their constitutional right to remain silent until they've had an opportunity to consult with an attorney. So with the revocation of the rather detailed guidance and the implementation or the declaration of the new standard, you might ask, in terms of your work, can ICE arrest individuals inside a protected area? Well, yes, they can under certain circumstances. In order to enter, they have to have a judicial warrant, not an administrative warrant from ICE that talks about apprehending somebody. In order to enter a protected area, they need a judicial warrant. That is a warrant that is signed by a federal judge or a federal magistrate, and it specifically identifies the person that they're looking for at that address. So under those circumstances, and of course, remember, there are always the exceptions. If there's an emergency, if there's a threat of violence, if there's imminent danger to anybody, law enforcement can act. We would want them to act if there's a threat to our safety. So we have on the books an imprecise standard. I mentioned a few minutes ago that if I had to bet, I would bet that the people who are now in charge at the Department of Homeland Security are going to be promulgating more specific standards as guidance. Whatever they do, that doesn't mean it's permanent. We have seen different versions of this type of guidance ever since 2011. We might even see changes in guidance that is announced tomorrow. And whatever is announced could also change if there's a new administration at some point. So it's important to stay abreast of what the rules are, knowing that even within the Trump administration, they are likely to change. That concludes my remarks, and I didn't go into specific strategies for different organizations, different agencies, and different functions. Rather, I thought I would give you what I consider to be is authoritative well thought out, clearly written materials that you can get at the NILH.org website. I'd be happy to try to answer any questions or refer you to places where I think you can get the answers to your questions.
Mark, I've got a question. This is Jeff.
Excuse me. So first, there's a question in the
Okay,
room.
sure.
Tell them that they must have a judicial warrant that identifies the person's name and the address they're searching. That it cannot be an administration or an administrative warrant.
Well, if you're talking about,
We want to make it as staff as possible on what the message is. If somebody does show up at an event that we're at, providing a service, or in our own private space, that they can't access that building.
so the question is, what advice should be given to staff from the standpoint of allowing or not allowing ICE agents access to the area of your agency. So there still is a difference between general public areas. So that's your waiting room, that's your parking lot, that's your bathrooms. I mean, areas that are accessible to the general public, as opposed to what are called private areas. So that is something that you have posted with signage that declares it to be a private area. Now, I'm not speaking to you personally, but I'm just saying as a general comment, people shouldn't try to get cute. They shouldn't try to just label every public area as a private area with a sign. I mean, obviously, that's not going to work. So if you think about the examples that were given in the guidance that has been revoked, but I mean, the reason I gave all those examples is just to give people an idea of what typically courts have recognized as protected areas. So if you are truly talking about something that is going to be regarded as a protected area, the first thing is signage to declare it. And now to your question, the materials that I referred you to are going to talk about training your staff so that there is a point person in your organization. So not everybody who works in your agency needs to be prepared to deal with communicating with law enforcement officials. They should be trained to refer any law enforcement official to a primary person that has been trained. So that person, I'll call him a point person or a designated person, that person needs to understand what to say in terms of exercising the right to not have, without a judicial warrant, ICE agents entering the private space. And there's a little nuance depending on whether you're talking about, uh, you know, different types of organizations, religious organizations, social services, hospitals, healthcare institutions. They also have HIPAA rules that are in place. Those haven't been revoked. So I think it is really helpful to try to open up the links that apply at the National Immigration Law Center, apply to the type of organization that you are dealing with. That'd be my best advice. Excuse me. Oh, there's another question from the floor.
A lot of us in this room, we do mobile operations and we go out to Abbotsford. We set up in neighborhoods. We try to meet people where they are. population is, or would you recommend that we continue to go to those areas that we've been going to so that those people know that they have resources?
I'll repeat the question for the online audience. The question is whether there's any thoughts or recommendations on organizations that have mobile areas, go out to, service areas, and whether there is a reason for any hesitancy to continue going to those areas because of fear that has been expressed in the immigrant community.
And the answer is yes. We still encourage everyone in this room who are servicing the communities we serve to continue operating as normal as possible. I can give you an example. On Wednesday night, Attorney Mark Bradley and Attorney Vanessa Avila gave a presentation in Atmosphere about Know Your Rights for parents and students. It was not an immigration topic. It was more about the school setting issues that have been happening in the Atmosphere school. We were surprised that we had 25 individuals in the room and 600 people. We changed to the hybrid. So if there is an opportunity to provide some type of training, do hybrid trainings, because we had 600 people watching that training and 25 people in the room. So we still reach out the population that we intended to, and it was very successful. And people are still, even though some people are afraid, a few still feel comfortable because they do have some type of documentation that they are not concerned about their immigration statuses. So we still need to serve those. And in the community, so all that created a WhatsApp group, and we are communicating different topics, and people in the community are being united right now. And some people have been offering those who are comfortable being outside, we can bring your food, we can bring your diapers, we can bring groceries. So people are being united at these times, and we still encourage everyone here to continue providing those services.
Is there a question from somebody online, I thought?
Yes, this is Jeff. This is Jeff Todd with the Wausau Free Clinic. Mark, thank you so much for providing this presentation. I'd like you to dive a little deeper, if you would, into the concept of the private areas and the Fourth Amendment. And the reason why is that in your presentation, you've kind of used the term private and protected areas sort of interchangeably. I've got the impression from the executive order that protected areas really have been taken off the table, and Mayorkas's definition really means nothing. But I do know that the Fourth Amendment has been adjudicated previously, both in case law and others, to define what a private area is that would stand the test if it was challenged. I know an exam room would be a private area where somebody would have a reasonable assumption of privacy. A home is a private area, but could you go into some detail? Because I think your point was really well taken, that you just can't define anything as a private area and assume an ICE agent is even going to respect that. The second part of my question is really, what do you do in the event that an ICE agent declares, in their opinion, at their discretion, there is a threat to safety, and demands, in the absence of a judicial warrant, that they want entry into a specific area? Do you just simply declare that I consider this to be unreasonable search and seizure and I protest? And I mean, what do you do?
So Jeff Todd from the Wausau Free Clinic, I don't know, could you hear his questions? Yeah. Asked two questions. So the first one asked me to comment on the distinction under our current standard from the Department of Homeland Security between protected areas, which is what the revoked guidance talks about, and private areas. If you read it literally, the directive that came out on January 25 has revoked the concept of protected areas, because protected areas were discussed in those previous guidances that I talked about from the Department of Homeland Security. That's been revoked. So legally or technically, if you're talking to somebody about a protected area or a sensitive area, that status doesn't exist anymore because it came from the department guidances in the past, which have been revoked. However, private areas, different term, private areas have been judicially recognized in the context of unreasonable search and seizures, places where I believe the standard is where a reasonable person would have a reasonable expectation of privacy. That still exists. So as Jeff mentioned in his question, an exam room at the Wausau Free Clinic, you wouldn't call that a protected area anymore. Technically, those don't exist. But under case law and recognized by the United States Supreme Court, there are private areas, and that clearly would be a private area. I believe we're going to have to wait until there's more definition given to the Department of Homeland Security's policies. But or until that happens, or if it never happens, I believe that ICE agents are going to have to use their common sense, knowing that if they don't use their common sense, they're going to be sued, and there might be consequences in court for their actions. I think most people, including ICE agents, would say, I think I can do my job a little better if I had some more specific guidance. So the concept of the private areas still exists. Protected areas, that terminology has been revoked. The second part of Jeff Todd's question was, so what do you do when or if an ICE agent appears at your facility or your agency, your institution, and says, under the circumstances, I am exercising my discretion with a healthy dose of common sense, and I want to enter this area of your facility. Well, I mean, I don't think you're going to arm wrestle them or tackle them or physically prevent them. One piece of advice that is pretty common is it is not against the law to record an interchange that you or your staff is having with any law enforcement official. So if you assert your position that you don't want to allow them permission to enter, if they insist that they're going to enter, they're uniformed up, and someone, either an ICE agent or some other law enforcement official, is probably armed also. So you can record them, you can videotape them. They might not like it, and they might ask you to stop. But there is nothing against the law for recording or videoing any altercation or any interchange with law enforcement. So the recommendation is, in order to have a record for going to your agency's attorney, notes made immediately after the event, or recording or videoing that occurred at the event, would be the thing that would be the most helpful for your attorney. That doesn't prevent the episode from occurring, but that is the best thing you can do to be prepared for challenging it. And you'll see that in the materials that I referred you to. Yes, Jane.
Allow them access without a warrant in a private setting, correct?
Correct. So the question is, in a private area, you don't have to permit ICE access without a judicial warrant. And that is true. That is still true, I should say. Has been true and is still true. Well, thank you very much for your attention, and in your agencies and your trade associations, wherever you try to get the most reliable information to help you out, just keep being vigilant, because most likely most of what I said is probably going to change. We just don't know how quickly it's going to change. And thank everyone on the video audience also.
Thank you very much, Mark.
Thank
You're welcome.
Thank you.